Now, in pension committee, you found that none of those 13 plaintiffs had acted willfully to destroy evidence, but you found that 7 of them had acted negligently, and 6 of them were grossly negligent. Now, what actions did you define as negligent?
Again, it's a very good question, and I promise to answer it. But again, before I do, I have to tell you my own thought processes when I thought about these 13 people. I knew that they had not had a shred day. They had not intentionally erased or wiped out a lot of information. And I said to myself, well, should I draft this opinion at all? Should I care about that which is negligent or grossly negligent? And so I always talk to myself. By the way, when you talk to yourself, you have a great audience. That's the good. So I have lots of conversations with myself. So when I finished talking to myself, I said, yes, it is important, I think, again, for educational purposes, to define what we expect. And so anything that is less than we expect is on a scale: negligent, gross negligent, reckless, willful, intentional. I mean, there is a scale. Because people can be hurt, that is, the party that doesn't get the information can be hurt even through negligent conduct. You don't have to have shred day to lose things. If it's lost, and the other party is not getting what in our system they're entitled to. So first of all, I have to say, I decided to go ahead with it with some trepidation. I knew I'd be criticized, and by the way, I have been, for even thinking about punishing merely negligent or merely grossly negligent conduct. But, you know, to be a judge, you have to believe in your decision, so I still think I was right because of what I said. The other party lost something, and that's important to me, to make sure everybody's getting a fair shake in the courtroom. So, what did I think was negligent behavior? The first thing I thought was the failure to issue a litigation hold. I guess I've become the guru or proponent or faith believer of litigation holds. It wasn't even done. These people were in litigation and they didn't issue a hold within their own company. They didn't get relevant information from all employees. They focused too narrowly on a very few players, knowing that information had to be more widely dispersed. They really made a very poor effort to preserve. They didn't supervise the employees who were doing self-collection. I think that's very important. The whole question of self-collection. Can the employee at their desk really be trusted to know what's relevant and what's not relevant? Are they trained to do that? Are they lawyers? No. Do they know the definitions? So they need to be supervised. They can't just pick and choose for themselves. And nobody assessed the accuracy or validity of search terms that were thrown out sort of to be used by these employees. So these employees were maybe told, here's 8 terms, go look for them. Did anybody test and see whether that was enough to collect the relevant data? So I thought that constellation of activity was negligent. Now, I want to just jump ahead to say the punishment for that was not very great. That group had a fairly mild punishment, but I thought it was worth articulating the conduct that I expected. Was that reasonable conduct? No, it wasn't. That's why I called it negligent. And do you want to know what I defined as gross negligence?
Actually, the slide will tell us, but
okay.
You will talk about it.
Okay. So then I had to go to the group, I think it was 7 and 6, so I thought some of these 13 had acted even worse. And what had they done? Again, they hadn't issued a litigation hold. They hadn't even identified the so-called key players, much less collect their information. This is a biggie. They didn't worry about former employees. And when I look at all the case law in these last 10 years, and now, by the way, instead of being 2 or 3 cases, there are 1,000 to look at, but former employees is constant. People leave the company. They were important in the deal because litigation is a retrospective activity. It's something that went bad 2 years earlier. The former employee is gone, and nobody paid attention to holding on to those records. They didn't seize the automatic deletion of email. Remember I mentioned the sort of 30-day routine deletion. Nobody lifted that 30-day rule. And they didn't even hold on to backup material at all when it was the only likely source of data. I was never preaching, and I've always said this, I've never preached that people have a duty to hold on to all backup. But if you know that the active data is gone and the only likely source is certain backup material, you have to keep it. They didn't. So it was that constellation of activity that I thought was grossly negligent. And again, there was different punishment for the negligent group and the grossly negligent group.